and welcome to part 7 of the Rape Gang Inquiry Report. Today we are continuing at Jihad and sex slavery. Islamic Sharia contains detailed regulations governing armed conflict, including provisions related to the institution of slavery. In Islamic law, slavery arises as a consequence of warfare against non-Muslims, infidels. Non-Muslim captives taken in such conflicts are regarded as lawfully enslaved simply by virtue of their capture. These captives may then be allocated to Muslim combatants as part of the war booty or spoils. They can subsequently be sold, ransomed, or retained in slavery. Historical records show that during the Prophet Muhammad's lifetime, Muslim forces enslaved women captured from enemy groups in more than a dozen military engagements. Under Sharia, sexual relations between a male owner and his female captive slave do not constitute zina. This is explicitly authorized in multiple Quranic passages, for example, Surah 4:24, 23:6, 70:30, and supported by numerous hadith precedents. Moreover, Muhammad taught that married non-Muslim woman captured in a war that a married non-Muslim woman captured in a war is automatically divorced from her previous husband by the act of capture itself. As a result, sexual intercourse between her Muslim captor owner and the formerly married captive does not amount to adultery. At first glance, it may appear incongruous to connect the classical Islamic institution of slavery with the sexual abuse of white girls in contemporary Britain. Yet the historical record reveals that a long-standing pattern of Islamic enslavement and sexual exploitation of white women. Historians estimate that between the 16th and 19th centuries, approximately 1 million Europeans were seized for profit as part of the Barbary slave trade. In March 1786, when Thomas Jefferson and John Adams inquired of Tripoli's ambassador to France why the Barbary states waged war on nations that had not attacked them, Sidi Haji Abdul Rahman reportedly answered, "It was written in their Quran that all nations which had not acknowledged the Prophet were sinners, whom it was the right and duty of the faithful to plunder and enslave, and that every Muslim who was slain in this warfare was sure to go to paradise." He said also that the man who was the first to board a vessel had one slave over and above his share. In recent times, Islamic terrorist groups such as ISIS have openly asserted the right to revive Islamic slavery. A significant contemporary legal debate among Muslim scholars concerns the proper classification of Western countries that now host large Muslim immigrant populations. In classical Islamic jurisprudence, any non-Muslim nation was presumptively categorized as Dar al-Harb, the house of war, from which Muslims had the right and duty to take slaves as articulated by the Tripoli ambassador. Medieval Sharia treated Dar al-Harb as the default status for infidel terrorists. A doctrine attributed to Muhammad further obliges Muslims residing in Dar al-Harb to perform hijra, migration, to a territory governed by Islam, particularly if they cannot freely practice their faith. This duty to migrate continues to be emphasized by many Salafi groups. In modern times, however, various adaptations have emerged to accommodate changed realities. Some authorities now classify Western nations as Dar al-Dawah, house of propagation, where Muslims enjoy freedom to invite others to Islam. In such circumstances, the obligation to wage jihad is thought to have been suspended. Other scholars maintain that an implicit covenant of security exists for Muslim migrants in the West. They are permitted to live and operate freely in exchange for refraining from jihad against the host society. It is worth emphasizing that the alternative classifications of Western countries, such as Dar al-Dawah or tacit covenant of security, serve only to postpone rather than eliminate the traditional obligation to engage in jihad. For at least some Muslims with radical inclination, the issue is not whether jihad will eventually be required, but merely when the appropriate moment arrives. Certain Muslim men lacking deep scholarly knowledge often rationalize their grooming gang offences by mentally recasting their victims in the role of legitimate slave property under an Islamic framework. In Rotherham, for instance, one perpetrator named Muhammad branded his victim with the letter M as a mark of ownership. Survivors have described being compelled to perform domestic tasks such as cooking and cleaning for their captors, while enduring repeated sexual violation, mirroring the treatment of household slaves. Journalist Andrew Norfolk captured this mindset when he observed, "Some of these Muslim kids have got an idea, probably because it's quite convenient for them, that Britain has been designated a land of war, so certain things have become permissible in terms of the enemy. I think some of these guys think it's okay to do stuff to white girls that they wouldn't dream of doing to Muslim girls." Dhimmitude, Islam's treatment of conquered non-Muslim people. Islamic jurisprudence also addresses the treatment of non-Muslim populations conquered through jihad. Classical Sharia rules in jihad defined as warfare waged against non-Muslims to extend the dominance of Islam, crystallized during the medieval era. As we have just noted, these rules divided the world into two fundamental categories: the Dar al-Islam, the House of Islam, territories governed by Islamic authorities, and the Dar al-Harb, the House of War, territories under non-Muslim control. Under this framework, non-Muslims fell into one of two groups. Those residing within the House of Islam were considered protected provided they fulfilled specific obligations and were not legitimate targets of military action. By contrast, those living in the House of War could lawfully be fought, defeated, and upon captured, enslaved. When non-Muslim communities came under Islamic rule, they were granted conditional tolerance through a formal surrender agreement known as the Dhimma Pact. This arrangement allowed dhimmis, protected non-Muslims, to retain their religion, but only on the condition that adult males paid an annual tax called the jizya and that the entire community observed a range of restrictive regulations. As the renowned commentator Ibn Kathir explained, these rules were designed to ensure their continued humiliation, degradation, and disgrace. If a dhimmi community was deemed to have violated the pact, whether by failing to pay the jizya or by breaching any of the imposed conditions, Islamic law permitted resumption of jihad. In such circumstances, the full Sharia regulations of war would apply. Adult males could be killed, women and children enslaved, and the property of non-Muslims seized as spoils. The Dhimma framework imposed a permanent condition of insecurity on Christian and other non-Muslim populations under Muslim sovereignty. It has supplied a religiously sanctioned cultural template that continues to underpin the abduction, forced conversion, and coerced marriage of non-Muslim girls in places such as Egypt and Pakistan. One way to view the involvement or lack thereof of British state officials in the rape gang scandal is an incorporation of dhimmi-like submissiveness. This mindset prioritizes deference to Islam and Muslims above all else, while dismissing or assigning fault to non-believers. From this perspective, the failure of authorities to act decisively against the grooming gang issue might represent a significant step in the gradual Islamification of Britain. Islamic clan culture. Evidence from the author and activist Ayaan Hirsi Ali at the inquiry highlights that grooming and rape gangs operating in towns such as Rotherham, Rochdale, and others are not isolated instances of criminality, but stem from an imported pre-modern clan system embedded within certain ethno-cultural communities, reinforced specifically by Islamic collectivism. As before stated, the crimes disproportionately involved perpetrators from Pakistani heritage backgrounds, with patterns rooted in honour and shame-based dynamics that are wholly anathema to British norms. The behaviour is deeply tied to tribal structures prevalent in parts of Pakistan, Afghanistan, the Middle East, North Africa, and Somalia. Family honour is primarily vested in the conduct, modesty, and virginity of girls and women. Strict codes require obedience, covering, and restricted interaction with outsiders. Breaches within the community trigger severe sanctions, including honor killings or collective retaliation by male clan members. When the target is a non-Muslim girl, particularly white British, perceived as unguarded, dressed in Western styles and lacking male protectors, the risk calculation shifts. No retaliation is expected from the girl's family or community, so some young men feel emboldened to treat her as property and then approach, assault, groom, share among the group, and sell her services. This proprietorial view of women escalates into organized networks that traffic girls across regions. Impunity fuels the cycle. Initial assaults without consequences create the perception of Britain as a place where such behavior carries no risk, turning vulnerable girls into commodified products. A key contrast emerged in evidence. When similar gangs targeted Sikh girls, the Sikh community mobilized men to confront and deter the perpetrators effectively. White working class girls lacked the equivalent collective protection, not least because the authorities often silence concerns, with accusations of racism allowing the abuse to persist and expand into modern-day slavery. Even second, third, or fourth generation immigrants raised in Britain continue these patterns, acting as demographic clusters where the clan system reproduces itself and intensifies, regardless of the wider culture. Ongoing immigration from such clannish foreign backwaters serves only to replenish and strengthen such communities. While the foundational system is tribal rather than purely religious, Islamic elements provide ideological justification, communal shielding, and strategic expansion. Perpetrators sometimes hide actions from families, mosques, and imams because the behavior brings disgrace to the community. Yet, remorse towards British victims is limited because non-Muslim girls are not viewed as fully human individuals deserving protection, but as unprotected outsiders available for abuse without moral consequence. This fosters widespread silence within affected communities. The inquiry evidence points to a fundamental clash of worlds across the West over our historic respect for the individual has, thanks to mass immigration, been overpowered by the more primitive attitudes that prevail elsewhere. According to which group membership matters first and foremost. The elite obsession with diversity has invited the latter to take advantage of the former. Scare words like Islamophobia and racism have been deployed to exploit the goodwill of Western host societies, paralyzing investigation and enforcement. Homegrown enabling factors. Islamophobia and political correctness. Concerns have long been raised that the fear of accusations of Islamophobia have inhibited open discussion and effective action on group-based child sexual exploitation cases, particularly those involving grooming gangs. A series of reports and analyses from the think tank Policy Exchange have documented how the charge of Islamophobia has been deployed to challenge, intimidate, or discredit individuals and organizations attempting to highlight the issue. In 2025, research note titled The Rotherham Grooming Scandal and the Creators of the Islamophobia Definition, Policy Exchange examined connections between the scandal in Rotherham and development of a contested definition of Islamophobia by the All-Party Parliamentary Group, APPG, on Muslims. The report highlighted the role of a key APPG staff member from Rotherham, Mubin Hussain, who in 2015 organised a community protest against South Yorkshire police, accusing them of scapegoating Muslims amid the grooming investigations, actions described by some local figures and inquiries as unhelpful to addressing the abuse. It also tells us a great deal about the politically correct institutional culture within Rotherham Metropolitan Borough Council, that in attendance at a safeguarding strategy meeting dated 6th June 2000 was an anti-racism coordinator named Bhupinder K. Malku. Similar themes appear in Policy Exchange's June 2025 publication, How Not to Tackle Grooming Gangs, which argues that the accusations of Islamophobia, independent of any formal definition, have been used to suppress exposure of the scandal and the pursuit of justice for victims. It recommends pausing government work on official Islamophobia definition until the conclusions of a national grooming gang inquiry are known. Politicians have echoed these worries in relation to proposed definitions. Shadow Equalities Minister Claire Coutinho has warned that adopting such a definition, particularly one framed as targeting expressions of Muslimness, could intensify the culture of censorship, potentially granting perpetrators greater impunity by making legitimate scrutiny of patterns in grooming cases more difficult or risky for police authorities and the public. She has argued this risks repeating past mistakes where fear of racist or Islamophobic labels contributed to delayed or inadequate responses. The concern to shield Muslims from criticism at all costs went hand in hand with a more general ideological shift organized around the unquestioning treatment of minorities as special victim groups. Rooted in the left liberal paradigm of the 1960s, this minoritarian outlook first scored political victories under Harold Wilson's Labour government. In time, tolerance and multiculturalism and anti-discrimination became highly prized values in elite circles. The law, too, began to foster an environment in which challenging certain minority communities, including Muslim ones, became politically dangerous and even criminal. This enables the grooming gangs to operate with impunity for years because authorities at every level, as we have seen, feared being labelled as racist or Islamophobic more than they feared failing the girls to whom they owed a duty of care. The legal framework that underpinned this paralysis began with the Race Relations Act in 1965 and its even stronger successor in 1976. These statutes, designed to combat overt discrimination, were interpreted and expanded in ways that made any discussion of ethnicity or culture in crime patterns hazardous. The McPherson Report of 1999, following the Stephen Lawrence inquiry, branded the police institutionally racist and introduced a definition of racism so broad that police officers and social workers became terrified of any action that could be construed as targeting ethnic minorities. Across Britain, clear evidence of organised abuse by Pakistani gangs among other majority Muslim ethnic groups was ignored because confronting it risked accusations of racism. The fear was not abstract. Senior officers and council staff explicitly cited concerns about so-called community relations and potential race riots for reasons for inaction. The country's transformation was greatly accelerated under Tony Blair's New Labour project, which culminated in the Equality Act 2010. This consolidated and strengthened so-called anti-discrimination protections by adding religion as a protected characteristic alongside race, combined with new hate crime legislation under Part 3 of the Public Order Act of 1986 and the Crime and Disorder Act of 1998. It created an environment in which criticizing aspects of Islamic culture or patterns of offending linked to Muslim communities could be framed as racial hatred or Islamophobia. Official definitions of Islamophobia promoted by some campaigns groups further blurred the line between legitimate concern and blind prejudice. The result was a chilling effect across public institutions. Police forces, social services, and local councils repeatedly chose silence or denial over robust investigations because the political and professional costs of appearing to single out Muslims was deemed too high. The KC National Audit of 2025 confirmed this pattern, noting that authorities shied away from examining ethnicity and culture even when the data pointed overwhelmingly to Pakistani Muslim perpetrators. What went wrong is now painfully clear. The post-war liberal consensus that began with Wilson emphasized diversity, inclusion, and non-judgmentalism as supreme virtues. Multiculturalism replaced a national self-confidence as the guiding principle. Long-standing British norms around free speech, child protection, and impartial application of the law were subordinated to the need to avoid offending minority sensitivities at all cost. Liberal elites in media, politics, and the public sector internalized the idea that acknowledging cultural or religious factors in crime was itself a form of bigotry. This mindset actively shielded the rape gangs by discouraging the very inquiries and interventions that could have saved thousands of children. Until the country rejects the fear of being called racist and restores the courage to name uncomfortable truths, the conditions that allowed these networks to thrive will remain. This inquiry records the damage without apology. The paralysis of our institutions was not some fluke. This was a predictable outcome of decades of legal and cultural changes that place sensitivity above justice. The law. The law of the land has not merely failed the victims of grooming gangs, but actively enabled the perpetrators. For decades, statutes that should have delivered swift, exemplary justice were either ignored, diluted, or deliberately misapplied in a manner that protected organized networks of predominantly Pakistani Muslim men while leaving thousands of British girls without protection or redress. The legal framework governing organized sexual exploitation, commonly described in public discourse as grooming gangs, is extensive but fragmented. It consists of overlapping criminal offences, human right obligations, civil liberties, and sentencing structures. While Parliament has enacted a broad suite of statutory provisions designed to criminalise sexual exploitation in all its forms, serious questions remain as to whether the law has been sufficiently coherent, proactive, or effective in preventing systematic abuse. At the core of the criminal law response lies the Sexual Offences Act of 2003. This statute represents the principal legislative mechanism for addressing rape, sexual exploitation, and grooming. It criminalizes a wide spectrum of conduct ranging from rape and assault by penetration to causing or inciting a child to engage in sexual activity and facilitating sexual exploitation. The Act also contains specific offences concerning abuse of positions of trust, trafficking for sexual exploitation, and paying for the sexual services of a child. Collectively, these provisions were intended to modernize and consolidate earlier sexual offences legislation. However, their practical operation in cases involving organized exploitation has often revealed structural limitations. The statutory framework presumes that the criminal justice system will detect and intervene early in the abusive patterns of conduct. In practice, many cases of organized abuse have involved prolonged periods during which victims were groomed, trafficked, and repeatedly assaulted without meaningful intervention by authorities. Subsequent legislation, including the Serious Crime Act 2015, expanded the concept of sexual exploitation to encompass a broader range of behaviors, including non-contact abuse and technologically facilitated exploitation. This expansion reflected an evolving understanding of grooming as a process rather than a single criminal act. Nevertheless, legislative reform has largely been reactive. It has tended to follow public scandals rather than anticipate systemic patterns of abuse. As a result, the legal framework often appears to be piecemeal rather than strategically designed. In cases involving organized sexual exploitation, prosecutors frequently rely on a constellation of offences rather than any single overarching charge. Perpetrators may be convicted of conspiracy to rape, trafficking for sexual exploitation, arranging child prostitution, and a variety of associated offences including drug supply and false imprisonment. Such cases demonstrate that criminal law is capable of imposing severe sentences, including life imprisonment, where the offending is particularly grave. Yet these outcomes tend to occur only after extensive investigations and multiple failures of early intervention. The law's capacity to punish extreme wrongdoing is therefore clear, but its capacity to prevent such wrongdoing remains contestable. Another critical dimension concerns trafficking and modern slavery legislation. The Modern Slavery Act of 2015 criminalizes human trafficking for sexual exploitation and provides full life sentences in the most serious cases. The intention in its passing was to recognize that organized sexual exploitation frequently involves coercion, movement of victims, and exploitation for profit. However, critics argue that the conceptual overlap between trafficking offences and traditional sexual offences has sometimes created uncertainty in charging decisions. The distinction between trafficking and exploitation is not always straightforward, particularly when victims are groomed into apparent compliance rather than transported by force. This ambiguity may complicate prosecutions and reduce the deterrent effect of the law. The legal framework also extends beyond criminal liability to encompass civil and human rights obligation. Article 3 of the European Convention on Human Rights, ECHR, imposes a positive duty on the state to investigate credible allegations of rape and serious sexual assault. Courts have held that systemic failures in investigation may constitute breaches of fundamental rights, even where perpetrators are ultimately prosecuted. This principle is of particular significance in organized exploitation cases, where victims have frequently alleged prolonged institutional inaction. The law, therefore, recognizes that state authorities may bear responsibility not only for direct wrongdoing, but also for failures to prevent or respond to grave abuses. Despite this extensive legal architecture, the operation of the law in practice has been inadequate. One recurring criticism is that the legal framework places significant emphasis on individual criminal acts while insufficiently addressing patterns of organized exploitation. Rape gangs typically operate through networks characterized by manipulation, coercion, and the economic exploitation. The law's traditional focus on discrete offences can obscure the systemic nature of such conduct. Although conspiracy and trafficking offences partially address the gap, there remains no single statutory offence that fully captures the phenomenon of organised sexual exploitation as a distinctly structured form of criminality. A further difficulty lies in evidential challenges. Grooming often involves psychological manipulation that undermines the credibility of victims in the eyes of investigators and juries. The legal concept of consent remains central to many sexual offences, yet it can be ill-suited to situations involving vulnerable children conditioned by their abusers to acquiesce. While courts have recognized that apparent consent may be illusory in such contexts, the statutory framework continues to rely heavily on more straightforward forms of evidence. This has at times created barriers to prosecution and contributed to the perceptions that the law inadequately reflects the realities of coercive exploitation. Moreover, the law's reliance on post hoc punishments raises broader questions about preventative capacity. Statutory offences are designed to respond once exploitation has occurred or is imminently planned. Preventative mechanisms such as risk orders and safeguarding duties exist, but their effectiveness depends on institutional vigilance and interagency cooperation. Where such cooperation fails, the legal framework offers limited remedies beyond retrospective accountability. This is insufficient to address organized exploitation that occurs over extended periods. Failure to invoke existing sentencing powers. The Crime and Disorder Act of 1998 and Sentencing Council guidelines explicitly permit, and in cases of demonstrated hostility require, an uplift in the imposed sentence where an offence is aggravated by racial or religious hostility. Evidence in grooming gang trials has repeatedly shown precisely this. Victims described as white slags, white trash, cuffer bitches, or told they were only good for men like me to fuck and use like trash. Perpetrators shouted Allahu Akbar and boasted of racial supremacy. Yet as far as available public records are concerned, the racial aggravations have never once been invoked against anti-white rape gangs, either by prosecutors or judges. This is in stark contrast to what tends to happen whenever white criminals are held to account for interracial crimes. Prosecutors did not hesitate, for instance, to pursue aggravating charges against Darren Osborne after he murdered a crowd of Muslims with his van in 2017, sentencing Osborne to life imprisonment with a minimum tariff of 43 years. The judge cited Schedule 21 to the Criminal Justice Acts of 2003 to confirm that a murder done for the purpose of advancing a political, religious, racial, or ideological cause counted alongside a terrorist connection as an aggravating factor in Osborne's crime. Sentences in rape gang cases, meanwhile, have remained at the lower end of the scale, often 4 to 12 years for men convicted of raping dozens of children over the years, rather than the life sentences or 20-plus year tariffs the offending merited. Shadow Minister for Justice Kieran Mullen drew attention at our hearing to the fact that many of those involved in rape gangs serve as little to a third of half their sentence. Worse still, foreign national perpetrators, many from Pakistan and other Muslim-majority countries, were rarely deported after sentencing despite clear powers under the UK Borders Act of 2007. Instead, they were housed and fed and upon release allowed to reoffend or return to their communities. In the Quilliam Foundation's analysis of 264 convictions 2005 to 2017, the overwhelming majority of perpetrators received terms that bore no relation to the lifetime harm inflicted. Even in high-profile cases such as Rotherham and Rochdale, ringleaders received effective tariffs that allowed release after serving less than half their sentence. This leniency persisted despite the organised, predatory and repeated nature of the crimes. Cultural defences and judicial relativism. British courts repeatedly allow cultural background to function as a de facto mitigating factor. In one Bristol case documented in the Quilliam report, a defendant argued that forcing a girl to have sex with his friends was simply Somali culture and tradition. In Rotherham, another claimed Western girls' clothing invited and provoked the abuse. These arguments were entertained rather than dismissed outright. Judges and defense counsels cited cultural sensitivity and to avoid empowering the far right or damaging community cohesion, the very phrase used in the case he reviewed to explain why cases were shelved pre-2012. The result is that men who viewed white British girls as subhuman property received discounts unavailable to any other category of offender. This is not justice under the law of the land, and it is the importation of foreign honour shame norms into the British courtroom, with the explicit acquiescence of senior police officers, prosecutors, and judges. Party politics. As Ayan Hirsi Ali told this inquiry, centre-left parties viewed Muslim voting blocs as protected base in aggressive prosecution or deportation risk losing those votes. Chronic electoral dependence in such blocs thus paralysed far too many levels of government. Political actors across the board, national, local and devolved, knew about the organised rape gangs for decades, yet put electoral survival, so-called community relations and fear of racism accusations before child protection. Labour Party figures proved especially guilty of making electoral calculations where they should have been looking out for the nation's children. Combined with demographic shifts in swing seats, this got in the way of concerted inaction. Scotland refused to hold its own inquiry before finally caving in February 2026. It continues to fail to record offender ethnicity or create specific child sexual exploitation markers. Early warnings from the 1980s onwards went ignored because addressing the offending risked political cost. Politics placed retention of power over the safety of children, allowing the gangs to operate with impunity for decades. Politicians received direct briefings, sat in multi-agency meetings, read internal intelligence, and still denied knowledge, blocked inquiries, and silenced critics in order to cleave Muslim voting blocs. This was not the ignorance of crime, but the calculated, repeated, and nationwide abandonment of children. The Labour Party. The Labour Party bears primary responsibility for the longest and most deliberate cover-up. As the former Conservative councillor Liam Billington emphasised to our inquiry, Labour-dominated local councils and MPs repeatedly prioritised electoral dependence on Pakistani Muslim communities above the safety of children. Jess Phillips MP and Naz Shah MP maintained public silence on the ethnic and religious patterns of the gangs while their constituencies suffered. Evidence shows that Labour politicians prioritised avoiding far-right empowerment narratives and ensuring so-called community relations over protecting victims. In Oldham, Labour councillors and leadership received one of our whistleblowers' social workers' disclosures on trafficking inside council-run and semi-independent units, yet retaliated against the whistleblower and took no remedial action. The same pattern occurred in Rotherham, Rochdale, Telford, Burnley and Peterborough. Labour councils surrendered streets, ignored parental reports, and allowed perpetrators to operate, among other reasons, because Muslim voting blocks were electorally vital. For former detective constable and Rochdale rape gang whistleblower Maggie Oliver has criticised the Mayor of Greater Manchester, Andy Burnham, with whom Oliver herself has worked, for failing to piece together a full picture of the information necessary to combat the rape gangs that still operate in his area. Despite ordering some preliminary independent reviews into CSE across Manchester, Burnham stands accused of focusing exclusively on the failures of the past. Oliver is on the record further suggesting that two trustworthy reviewers resigned from the final phase of Burnham's inquiry, dealing with the years 2019 to 2025 because they were blocked by Greater Manchester Police from accessing vital documents and speaking to some survivors. As Oliver puts it, what I had come to see and believe is that whilst the PR machine was wheeled out very well about what was already in the public arena, when it comes to leadership and courage and gripping what is going on now, unfortunately he, Burnham, turned away. We missed a huge opportunity to bring the changes that are needed. Even reviews that did produce valuable findings have seldom been followed by decisive action. Commissioned in 2017, Burnham's limited independent review concluded that authorities failed to protect children from paedophile gangs in Manchester, Oldham and Rochdale. However, no officers were fired or stripped of their pensions for the historic failings exposed, nor has Burnham exercised his powers as Police and Crime Commissioner, a position he automatically holds an extension of his mayoralty, to prosecute any of the officers found to have failed the victims of predatory gangs. Labour politicians did not merely fail to act, but actively denied that the problem existed, smeared those raising alarms, and blocked local inquiries that could have revealed the full scale. They sacrificed thousands of white working-class girls to its electoral alliance with Pakistani Muslim communities and the general reputation of multiculturalism among the public. Such institutional paralysis was not accidental but political. For even when a few Labour politicians such as Sarah Champion did speak up, they were dismissed. In Rotherham, Rochdale, Oxford, Telford and dozens of other towns, Labour-controlled councils and police forces repeatedly shelved investigations, threatened whistleblowers with racism accusations, and instructed officers not to record the ethnicity of perpetrators. The 2014 J report exposed how Labour councillors and senior officials in Rotherham dismissed the systemic rape of 1,400 girls because to do otherwise risked alienating the Pakistani community. This pattern was repeated nationwide. This betrayal continued into government. In January 2025, Labour MPs voted en masse against Conservative amendment calling for a national statutory inquiry into grooming gangs. The amendment was defeated by 364 votes to 111. Sir Keir Starmer and his front bench abstained or opposed the measure, dismissing public concern as far-right agitation. It took sustained external pressure, including the damning Casey national audit, this independent inquiry and public outrage, to force a U-turn in June 2025. Even then, the government watered down local inquiries with reports that plans for 5 separate reviews were quietly dropped to avoid offending Pakistanis. Jess Phillips, appointed safeguarding minister, had much to do with his show of contempt by the Labour Party. Survivors resigned from her victim panel in disgust, condemning the process as a sham. Phillips apologised for delays but retained the full backing of Sir Keir Starmer. Under her watch, ethnicity recording remains patchy and the anti-white aspect of those horrendous crimes continues to be downplayed. This is the same Labour Party that has consistently weaponised the accusation of Islamophobia to silence anyone who stated the obvious that the gangs were and remain overwhelmingly Pakistani Muslim men. As a result, the nation has suffered decades of state-enabled child rape on an industrial scale. This is where we are going to end today. Thank you very much.